It's my privilege to speak today before Korea's Citizens Coalition for Social Justice. The formation of this coalition and the very recent adoption of Korea's new Anti-Corruption Act sends strong signals to the rest of the world that Korea is determined to be a leader in the pursuit of justice and the rule of law. Indeed, it should be pointed out that in the most recent edition of the Rule of Law Index, published by the World Justice Project, Korea ranked 14th out of a total of 99 countries, covering approximately 95% of the world's population. So Korea has already become a leader in the pursuit of justice and the rule of law. It should also be mentioned that corruption, or the absence of corruption, is just one indicator of a society's commitment to the rule of law. Constraints on government powers, order and security, the protection of fundamental rights, and access to justice are other factors relevant to assessing a society's adherence to the rule of law, in addition to the absence of corruption. The World Justice Project Rule of Law Index assesses 8 such factors. But of course, the absence of corruption is a very important indicator of a society's achievement of the rule of law. It was Pratibha Patil, the 12th President of India and the first woman who held that office, who stated, and I quote, "Corruption is the enemy of development and of good governance. It must be got rid of. Both the government and the people at large must come together to achieve this national objective." And there are countless studies of the effects of corruption on economic growth and development, so many that the corrosive nature of those effects is no longer in any doubt. I was asked to speak at this event about how certain U.S. government agencies promote and enforce the rule of law. This is a very broad subject, as the U.S. government is very large and numerous federal government agencies have regulatory responsibility or otherwise promote the rule of law. And of course, it should be mentioned that under our federal system, each of our 50 states also has numerous agencies whose regulatory and enforcement powers also reflect a commitment to the rule of law. Today, I will describe certain federal laws directed to ethics and the rule of law, and certain federal agencies and offices having responsibility in those areas in the United States applicable to lobbying. This paper is by no means an all-inclusive treatment of these complex issues, and should be viewed as an introduction to subjects that have been studied and debated exhaustively for decades, and is often referred to as the U.S. Criminal Code, and apply to official acts performed by, quote, public officials, unquote. Among other things, the statute applies to both the giving of anything of value with the intent of influencing a public official to commit fraud or violate his or her duty as such, as well as the receiving of anything of value, with the intent of being so influenced. Under this statute, bribery is a crime, defined in broad terms with severe penalties. Conviction on even one count of bribery can result in a fine of up to 3 times the amount of the bribe, up to 15 years in prison, and disqualification from holding public office thereafter. There have been many prosecutions for bribery and many convictions since this federal statute became effective. Just within the past 2 weeks, it has been publicly reported that a U.S. senator has been indicted on 14 corruption accounts, including bribery, reportedly the first federal criminal charges against a U.S. senator since 2008. It should be mentioned that the U.S. Criminal Code and federal bribery laws do not generally apply to so-called commercial bribery, which involves corrupt dealing with potential customers to gain competitive advantage over competitors, including by means of kickbacks. Commercial bribery is usually treated as a felony under state law, although it is reported that only 36 of the 50 U.S. states actually have laws specifically prohibiting commercial bribery. But even though prosecution of commercial bribery generally requires the application of state law, interstate commercial bribery may invoke application of certain federal laws, such as the federal mail and wire fraud statutes. The U.S. statute regarding corruption that perhaps draws the most attention is the Foreign Corrupt Practices Act. As may be well known by those in attendance at this conference, this 1977 federal statute addresses bribery of foreign, non-U.S. government officials, as well as certain other wrongful conduct. It was enacted over the objection of many U.S. companies which contended that bribery and related forms of corruption were widespread around the world, and that to punish U.S. companies for engaging in them would place those companies at a significant competitive disadvantage in carrying out international business. While the U.S. once stood almost alone in criminalizing bribery and other forms of corruption in international business, the destructive effects of those practices are now widely recognized, and numerous other countries have established or are now establishing similar legal regimes concerning them. The Foreign Corrupt Practices Act has had a significant effect on the conduct of multinational companies doing business out the U.S. Very significant penalties have been imposed on some such companies by the two U.S. federal agencies responsible for enforcing it, the U.S. Department of Justice, or DOJ, and the U.S. Securities and Exchange Commission, the SEC. The principal U.S. statute which specifically addresses ethics and the rule of law in the federal government is the Ethics in Government Act of 1978, passed in the wake of the Nixon-Watergate scandal, the so-called Saturday Night Massacre, and a variety of other scandals which occurred in that time period. It has been said that this was the first time in U.S. history when misconduct was a repeated, near constant theme in the mainstream press. The primary focus of federal law concerning ethics is on disclosure, on the theory that transparency and sunshine, quote unquote, are the best cure of wrongful conduct in government activity. The Ethics in Government Act created mandatory public disclosure of financial and employment history of public officials and their immediate families. Under the Act, nearly all federal officials in all three branches of government, the executive, legislative, and judicial branches, are required to file disclosures of outside income, investments, income of a spouse and dependent children, gifts, reimbursements, and personal liabilities. A person who knowingly and willfully fails to make the required disclosure, or who falsifies information required to be reported, may be subject to civil penalties as well as criminal prosecution. Civil penalties for violations of the Ethics in Government Act can range up to $50,000. The standards for civil prosecutions under the Act are less demanding than those for criminal prosecutions. Specifically, for a criminal prosecution to proceed, a falsification or failure to report must be, quote, knowing and willful, and the information in question must be material. Materiality in this context has been held by the U.S. Supreme Court to mean falsification or a failure to make required disclosure which tends to conceal in any degree material that would prompt or affect investigation. The Ethics in Government Act restricts outside employment on officials earning more than a specified amount, which is subject to adjustment depending on the location of employment. Such an official cannot be employed by an entity which provides professional services involving a fiduciary relationship, have his or her name used by that entity, be a member of the board of that entity, or teach without prior authorization by the appropriate government ethics department or figure. It does allow for judges to teach when not on active duty. I'll turn now to certain anti-corruption offices and organizations within the federal government. The primary agency responsible for enforcement of federal anti-corruption laws, including the U.S. Criminal Code and the Ethics in Government Act, is the DOJ, the Department of Justice. A referral for investigation is made to DOJ when there is reasonable cause, quote unquote, to believe violation of the Ethics in Government Act may have occurred. Once a matter is referred to DOJ, civil or criminal prosecution is at the discretion of the U.S. Attorney General, the senior official within DOJ. The Public Integrity Section, PIN, of DOJ is the specific office within DOJ which is charged with combating corruption at all levels of government, including prosecution of corrupt federal, state, and local elected and appointed public officials. The PIN was likewise created in the wake of the Watergate scandal in 1976. PIN has approximately 30 prosecutors who assist local U.S. attorney offices in handling complex corruption cases. The Ethics in Government Act requires PIN to report annually to Congress on its operations and activities. In 1980, there was created the Election Crimes Branch, PIN, which supervises cases involving voter fraud, campaign finance offenses, and other election crimes. Of course, given the federal system in the U.S., each of the 50 U.S. states also has a substantial agency corresponding to DOJ, which is responsible for enforcement of state law in the state in question. The Judicial Conference, a body of senior judges responsible for framing policy guidelines for administration of the federal judicial system, is required to refer to DOJ any person it believes has willfully failed to comply with federal judicial disclosure requirements. A useful summary of the applicability of the Ethics in Government Act to the federal judiciary has been published by Alliance for Justice, a judicial watchdog group in the United States that represents a coalition of 100 politically liberal groups that have an interest in the federal judiciary and monitors appointments to the federal branch. That summary can be found at the website of the Alliance for Justice, which is identified in my paper. Next, I will address the positions of inspectors general. In the U.S., the term inspector general refers to an in-house official responsible for examining the actions of the government agency of which he or she is a part, in the nature of a general auditor, to assure compliance with laws and policies and to discover fraud, theft, or certain types of criminal activity. The initial federal statute creating Inspector General provisions in the federal government, the Inspector General Act of 1978, authorized the appointment of 12 such offices, but today approximately 75 federal agencies have inspectors general. In some cases, these are appointed by the U.S. President, and in some of those cases, the appointments could be characterized as political in nature. In other cases, the appointment is made by the head of the agency in question. Inspectors general can and do employ investigators of various types, including forensic auditors and a variety of other specialists. Inspections may focus on conduct of government employees or on domestic or foreign outside parties such as government contractors, grant recipients, or recipients of federal loans. Some federal inspectors general have law enforcement authority. Federal inspectors general share information and coordinate among themselves through the Council of Inspectors General on Integrity and Efficiency, an independent entity within the executive branch created in 2008. In addition to federal inspectors general, there are numerous inspector general offices at the state and local level. The U.S. has a long history of relying on special prosecutors to address particularly serious allegations of government corruption. But it was the Watergate and related scandals of the 1970s that led to institutionalization of a special prosecutor function. The Ethics in Government Act of 1978, mentioned above, provided for the appointment by the U.S. Attorney General of an independent special prosecutor whenever he or she received charges of specific misconduct, unless the allegations were so unsubstantiated as to not warrant further investigation. Since that time, the independent prosecutor regime established by the Ethics in Government Act has been revised and refined and criticized and subjected to judicial scrutiny numerous times. From time to time, the Attorney General's authority and discretion in this area have been enhanced or constrained. Greater controls on special prosecutors themselves have been imposed, and the extent of financial oversight and reporting responsibilities has generally been increased. The term special prosecutor was itself eventually replaced by more neutral independent counsel nomenclature. An independent counsel under the original statute, who was appointed by a special panel of federal judges, could investigate allegations of any misconduct with an unlimited budget and no deadline, and could be dismissed only by the Attorney General for good cause, or by the special panel of the court when the independent counsel's task was completed. As the President could not dismiss those investigating the executive branch, it was felt that the independence of the office would ensure impartiality of any reports presented to Congress. However, critics argued the independent counsel regime essentially created a fourth branch of government that had virtually unlimited powers and was answerable to no one. In the late 1980s, the independent counsel regime was challenged in landmark litigation that ultimately ended up in the U.S. Supreme Court on the ground that its statutory basis, the Ethics in Government Act, an act of Congress which made the Inspector General regime applicable to the executive branch, violated the fundamental separation of powers principle of the U.S. Constitution. But in its landmark 1988 decision in Morrison v. Olson, the U.S. Supreme Court upheld the constitutionality of the independent counsel statute, finding that it did not unduly or impermissibly interfere with the executive branch. I will now briefly describe the U.S. Office of Government Ethics. The Ethics of Government Act, mentioned above, also provided for the creation of the U.S. Office of Government Ethics, often referred to as OGE. OGE provides overall oversight of ethics programs within the executive branch of the federal government that are intended to prevent and resolve conflicts of interest. It administers an extensive financial disclosure system, ensures that ethics programs throughout the executive branch comply with applicable ethics laws and regulations, provides ethics education and training, and provides technical assistance concerning ethics to state, local, and foreign governments and international organizations. Because it is part of the executive branch of the federal government, it has no jurisdiction over ethics programs of the legislative or judicial branches of the federal government, nor does it have any jurisdiction over state or local ethics programs. Further, its mission is one of prevention. It does not adjudicate complaints, investigate matters within the jurisdiction of other authorities, or prosecute ethics violations. The OGE director is appointed by the President and approved by the Senate. He or she is charged with providing direction on executive branch policies of disclosure and collaborates with the U.S. Attorney General in investigations of ethics violations. Within the executive branch of the federal government, there are more than 130 agencies, and the head of each such agency is responsible for administering the ethics programs in that agency. To administer the day-to-day activities of the ethics program, each agency head appoints individuals to serve as the agency's designated agency ethics official and an alternate designated agency ethics official. Depending on the size of the agency, additional personnel may also be appointed to assist in supporting the agency's ethics program. According to the OGE website, again cited in my paper, approximately 5,500 full-time and part-time ethics officials work in the executive branch to provide assistance in identifying and resolving potential conflicts of interest by collecting and reviewing employees' financial disclosure reports, providing ethics training, counseling employees on ethics and standards of conduct issues, and maintaining compliant agency ethics programs. The effectiveness of the OGE is sometimes questioned, especially as to whether it can develop and enforce regulation with limited budgetary resources and leadership. I'll turn now to a brief summary of lobbying laws in the United States. Lobbying is common in the U.S. at all levels of government, national, state, county, and municipal. The practice has deep roots in American political life and can be traced to the First Amendment to the U.S. Constitution, which provides for free speech and the right of citizens to petition the government. Because of extensive registration and disclosure requirements, significant information concerning lobbying in the U.S. is available. The advent of the Internet has greatly enhanced the ability of members of the public to obtain information regarding lobbying laws and practice in the U.S. For example, the Center for Responsive Politics, a nonprofit, nonpartisan organization based in Washington, D.C., tracks the effects of money and lobbying on elections and public policy. Its website, cited in the paper, is a publicly available source of information about lobbying in the U.S. at the federal level. Lobbying in the U.S. is a significant activity and is the subject of detailed regulation and widespread study and commentary. Lobbying is usually described as paid activity for the purpose of influencing decisions of public officials. Often the objective is to influence the legislative lawmaking process. It can also be directed toward administrative action by one or another government agency. The latter category would include situations where a lobbyist acts on behalf of a party doing business or seeking to do business with the government in question, such as by selling goods or services to the government. corporations and other business organizations, nonprofit organizations, labor unions, trade associations, religious organizations, and even other governments engage in lobbying in the U.S. For example, many state, county, and municipal entities in the U.S. engage in active lobbying at higher government levels. I'll turn briefly to federal regulation of lobbying. The very first efforts to regulate lobbying at the federal level occurred in the late 1800s, but the first significant federal legislation directed specifically at lobbying was the Foreign Agents Registration Act, often referred to as FARA, enacted prior to the outbreak of World War II. Its primary purpose was to limit the influence of foreign propaganda, particularly Nazi propaganda, on U.S. public policy. FARA focused not on limitation or severe regulation of lobbying, but on disclosure, by requiring agents of a foreign principal to register, including identification of foreign principals, to label in a conspicuous manner literature or other information disseminated on behalf of foreign principals, and to maintain and disclose comprehensive diaries of contacts with foreign principals and compensation received from them. The intent was not to limit the distribution of foreign propaganda, but to identify it as paid for and distributed by agents of foreign principals. FARA is administered by DOJ, which evaluates the statements and activities of so-called foreign agents in light of their function as such. FARA covers political activity, public relations counsel, publicity agents, information service employees, political consultants, fundraisers, or those who represent a foreign power before any agency or official of the U.S. government. It does not include news or press services not owned by a foreign principal. Although the initial focus of FARA was on foreign propaganda, the statute was amended in 1966 to emphasize agents actually working with foreign powers who sought economic or political advantage by influencing U.S. government decision-making. This increased the government's burden of proof, and it has been reported that there have been no successful FARA prosecutions since then. However, civil injunctive remedies enabled DOJ to issue warnings of possible violations of FARA, ensuring greater voluntary compliance, but also making it clear when FARA has been violated. This has reportedly resulted in a number of successful civil cases and administrative resolutions since that time. The enactment of the Lobbying Disclosure Act of 1995, discussed below, removed from the scope of FARA certain agents engaged in lobbying activity who register under that statute. In essence, to briefly summarize, the Lobbying Disclosure Act of 1995 meant that all the foreign governments, Disclosure Act of 1995, so FARA is now really limited to government and government-controlled entities. According to the DOJ website cited in the paper, as of March 27, 2015, 2 or 3 weeks ago, agents of 528 non-U.S. principals, including 24 from Korea, were registered under FARA. After enactment of FARA, the next major federal legislation concerning lobbying was the Regulation of Lobbying Act, enacted in 1946. This statute and the thinking underlying it, similar to that regarding FARA, did not assume that lobbying was necessarily improper and required limitation or severe regulation. Instead, the focus was, and has been ever since, on disclosure, on the theory that it is important that the public be able to determine who is attempting to influence Congress. Hence, registration of lobbyists and financial disclosure became the primary means for enabling the public to achieve the goal of the 1946 statute, to give the public the ability to evaluate the political pressures to which members are regularly subjected. The 1946 statute was superseded by the Lobbying Disclosure Act of 1995, which established rules applicable to both individuals who engage in lobbying and lobbying firms or other organizations. This remains the primary U.S. statute regulating lobbyists, although it has been amended in significant respects in the years since its enactment. It applies to both individuals who engage in lobbying and lobbying firms, as well as elected and appointed U.S. government officials and members of their staffs, all of whom must become familiar with this legal framework. Registration with the two bodies of Congress, the Senate and the House of Representatives, is required by those who lobby their members, and quarterly reporting of lobbying activity is required. Exemptions apply when the lobbying income or expenses do not rise above certain specified minimum levels. Both houses of Congress have adopted rules concerning gifts to members or employees of Congress, which address such issues as the definition of a gift, which can include entertainment, hospitality, loans, lodging and meals, and other items, the value of permissible gifts, both individually and in the aggregate, and a number of other criteria. In addition to rules of general applicability, both houses of Congress have specific prohibitions against gifts from registered lobbyists. But there are numerous exceptions to the prohibitions against gifts to members and employees of Congress. Public Citizen, a nonprofit consumer rights advocacy group based in Washington, D.C., publishes the rules of both houses of Congress applicable to gifts. It has been reported that in 2014, over 12,000 lobbyists were registered at the federal level, although it has also been suggested that the number of individuals actually engaged in lobbying at the federal level is actually much higher. It has been reported that during the period 1998 to 2010, the industry sectors which spent the most on lobbying at the federal level were, in descending order, first, finance, insurance, and real estate; second, healthcare; third, communications and electronics; fourth, energy and natural resources; fifth, transportation; sixth, agribusiness; seventh, defense; and eighth, construction. It has been reported that during that period, those industry groups spent more than $19 billion on lobbying. It should be noted that special rules apply to lobbying federal government officials and agencies by which the lobbyist in question was recently employed, the so-called revolving door phenomenon. The Ethics in Government strengthened the prohibitions against lobbying before an agency by which one was previously employed. Now, there also exist lobbying regulations in all 50 of the U.S. states, and many, if not all, major U.S. cities also have their own municipal lobbying rules. In some cases, those municipal rules merely refer to the state laws, rules, and do not impose their own separate municipal rules, but in other cases, cities have their own municipal rules. In my paper, I cite some websites, and I refer in particular to New York City and Chicago as examples of very sophisticated databases, very sophisticated registration requirements, and sophisticated databases concerning lobbying. And those are merely examples. Virtually all major U.S. cities have extensive registration and disclosure requirements concerning lobbying. That concludes my presentation. I thank you very much for your attention, and I hope my remarks will contribute to the success of this symposium. Thank you.